is three of our colleagues from Aberdeen, Professor Burcu, Yüksel, Ripley, Dr. Alisdair MacPherson and Luci, Carey, who are going to be giving us an update on digital assets in Scots private law. I don't know which one of you is going to start. Burcu, are you going to start?
Yes, I will, and I have some PowerPoint to share. Second. I hope you can all share my screen now. Yeah. And, thanks very much for the opportunity to present today on the research project of digital assets in Scots private law, which we recently conducted at the University of Aberdeen and which was generously funded by the Royal Society of Edinburgh. And today we will be sharing with you the findings of the project concerning electronic trade documents and crypto assets. Just a few words on as an introduction. Digital assets are significantly underexplored in Scots law. There's no specific provision on digital assets in Scots private law. There's a general absence of case law on digital assets, and there has been only a limited amount of scholarly work on digital assets from a Scots law perspective. As a positive note, the Scottish Government established an expert reference group on digital assets, which undertook some valuable work in the area and made some recommendations. And very recently, the Scottish Government launched a public consultation seeking views on its proposed reforms to Scots private law in respect of digital assets. And this project we conducted was timely and important for Scotland. And we examined to what extent digital assets are already accommodated within Scots private law, which areas of law require reform, and how these can be best advanced in Scotland. And we collaborated with four distinguished lawyers across Scotland: Professor David Fox, Dr. Simon Lamont-Blanc, Dr. Lorna Gillies, and Fiona Henderson. And as part of the project, we organized 3 workshops to discuss matters relating to digital assets. The workshop reports are all available on our project website, and the project article is currently under consideration for publication. And now I hand over to Luci first for the project findings on the implications of the electronic trade documents law reform for Scotland, and then to Alisdair regarding the findings on crypto assets.
Thanks, Burcu. Hope everyone can hear me okay. So in workshop 1, we discussed the background to the Law Commission's Law Reform project on electronic trade documents and the need for reform. And we noted that although the Scottish Law Commission was not involved in the project, some specific provisions that were specifically applicable to Scotland were introduced in the Electronic Trade Documents Bill. We also looked at how the Electronic Trade Documents Act plugs into certain acts, such as Carriage of Goods by Sea Act 1992 and the Bills of Exchange Act 1882, which apply in Scotland as well as in England and Wales. But of particular interest in Scotland is the Movable Transactions Scotland Act 2023, and we discussed how that interacts with the Electronic Trade Documents Act. So Section 42 of the Movable Transactions Act permits a pledge to be created over corporeal movable property, either by delivery or by registration. Under Section 42, subsections 1 and 2 of the Movable Transactions Act, a possessory pledge can only be created over corporeal movable property and by delivering that property to the creditor. So therefore, documents, paper or electronic, cannot give rise to such real security in respect of the goods that they represent. But Section 44, subsection 1D provides an exception to this by enabling the creation of a possessory pledge by delivering a bill of lading representing the property to the relevant person. So by considering the theoretical possibility of delivering a different type of paper trade document with the intention of creating a possessory pledge over the document itself, and to enable this to be achieved with an equivalent electronic trade document, a provision was included in the Electronic Trade Documents Act relating to Scotland. So under Section 3, subsection 4 of the Electronic Trade Documents Act, an electronic trade document is to be treated as corporeal movable property for the purposes of any act of the Scottish Parliament relating to the creation of a security in the form of a pledge over movable property. But there still remains uncertainty as to what types of trade documents other than bills of lading could potentially create a pledge over movable property. The wording which places an electronic trade document within a particular category of property in Scots law to ensure legal parity between an electronic trade document and its paper equivalent in relation to pledge doesn't seem to be in line with the Electronic Trade Documents Act functional equivalence approach. And it was suggested in the workshop that it would be preferable to achieve legal parity by alternative wording that focuses on the ultimate legal effect of the electronic trade document rather than its property categorization. Further issues that were identified as needing further attention include what constitutes a reliable system. So an electronic trade document can be possessed in the same way as a paper equivalent, provided it is on a reliable system. And the guidance as to what is a reliable system is contained in the Act itself in Section 2, subsection 5. But determining the reliability of a particular system appears to be left to courts to decide on a case-by-case basis. In the absence of an international standard or an accreditation regime for system providers, as is done, for example, in Singapore, the suggestion from our research is that the system should be presumed reliable unless proven otherwise, on the assumption that parties would not have used that system as prudent businesses or traders. Interoperability between systems is also going to be very important for the facilitation and sustainability aspects of international trade. Another issue is the change of form. Section 4 permits a trade document to change form from a paper document to an electronic document and vice versa. And we discussed if this might create some practical issues. So, for example, how would a person dealing with an electronic trade document know if it has been converted into a paper document so that that electronic version is now defunct? Or how would a person dealing with a paper document converted from an electronic document know that all the conditions required by Section 4 have been complied with? This ability to change form may, although we all discussed that this is not certain, may increase the risk of fraud. But despite these points, overall, the view of the workshop participants is that the Electronic Trade Documents Act is a very welcome reform for Scotland. So with that, I shall pass over to Alisdair.
Thank you very much, Lucy. Now, the first thing to mention in relation to crypto assets is the lack of authority in Scotland. As Burcu mentioned, there is almost no case law. The only reported case we have is in relation to criminal law, and there is very little by way of academic commentary. Despite that, we know that there are various areas of private law that are of relevance in relation to crypto assets, including all of the areas mentioned here. So in terms of the second workshop, we had experts in relation to each of these areas participating. And positively, the general view was that crypto assets can be accommodated under Scots law in these areas, albeit that there were some issues identified, including in relation to things like remedies and enforcement. There was a general recognition of the importance of the property status of crypto assets, because property law provides a framework which also answers questions in other areas of private law. And with respect to that, the general view was that some legislation would be desirable in order to provide greater certainty and clarity. And I think that's more necessary in Scots law than it is in English law, largely because of the absence of authority in comparison to England and Wales. There was, however, a consensus that any legislation shouldn't be a code or very detailed. It should be relatively brief and neutral in terms of technology. There was a desire for practitioners to be able to experiment and come up with new innovative legal solutions without being too constrained by legislative provisions. And it was recognised as well that courts would play a significant role. So if obviously you have a shorter, briefer piece of legislation, there's a general greater likelihood for judges having flexibility to come up with appropriate legal solutions. As regards the content of legislation, a number of different aspects were mentioned, including the ones highlighted on the slide here. So confirmation of the property status of crypto assets, so confirmation that they can be a property object, and also in terms of the particular property category that they fall into. This is not as controversial an issue as it is in England and Wales. it generally seems to be accepted that they are a special type of incorporeal movable property, given their intangible nature. But because of their special status within that broader category of incorporeal movables, there's some desire for there to be clarification of the rules regarding transfer, the extent to which control is a fundamental feature of transfer of ownership of crypto assets, and whether on-chain and off-chain transfers would both be permitted in terms of transferring ownership to another party. And where you have someone who provides value and obtains property in good faith, whether they would acquire ownership from a non-owner. Another key issue is in relation to enforcement against crypto assets, especially debt enforcement, but also extending to other types of involuntary transfer, like in bankruptcy. The mechanisms that exist under Scots law at present just seem to be inadequate and inappropriate for this type of asset, so there probably needs to be greater attention given to those matters. And as Burcu mentioned earlier, the Scottish Government is helpfully at the moment consulting in this area, I think in part probably motivated by what's going on in England and Wales, and also as a result of recommendations provided by the Scottish Government's expert reference group led by Lord Hodge and David Fox. And a number of their recommendations in relation to property issues, including the points on this slide, are being taken forward by the Scottish Government, and they're proposing legislation in this area. There isn't so much in the consultation regarding things like enforcement, so that is an area that they will need to give further attention to, and certainly something that we in our consultation response will be picking up on. But yeah, the consultation is open until the 5th of February in case anyone wants to have a look and potentially submit a response. Burcu, over to you.
Okay, thanks very much. The last phase of the project focused on intra-UK and international dimensions of digital assets, and particularly private international law matters and developing international frameworks. The Ancestral UNIDROIT and the HEC conference have carried out some important work in the area, and for the future, the HEC conference digital tokens project is particularly important from a PIL perspective and should be monitored closely as part of Scotland's reform agenda on digital assets. In relation to electronic trade documents, the Electronic Trade Documents Act has no provision expressly defining its sphere of application or clarifying its interaction with PIL, and our project findings suggest that this raises uncertainties and concerns, and they need to be addressed. And we already heard from Laura and Amy in relation to the Law Commission's ongoing work on this area, and we think that work could offer a valuable basis for a possible UK-wide law reform and collaboration in this area to address such concerns. In relation to crypto assets, a number of points have cropped up. I will just mention a couple of them in the interest of time. Characterization and the distinction between on-chain situations among system participants with internal effects and off-chain situations with external effects seem important. And if a contractual characterization is adopted for relationships among system participants, this can offer a workable PIL solution for on-chain situations. Party autonomy is well recognized for contractual matters in Scots PIL and can bring legal certainty and predictability for both contractual and proprietary matters among system participants. Regarding the status of crypto assets in off-chain situations, there's uncertainty about that, as Amy mentioned also, and we think that the Scottish courts can take the view that it's the place of habitual residence or business of the last known holder of the crypto asset. The identification of the defender would be another difficulty, given that in Scotland, one cannot secure an interdict directed generally against anyone who has notice of it or sue persons unknown, which is different than England and Wales. And this issue and alternative means of service, for example, via an NFT airdrop, require further attention in Scots law, potentially by way of a legislative reform. And beyond this, we think that Scotland should take a minimalist and simple approach and reform in the first instance its substantive private law only. further information about the project is available on our project website. Thanks very much.
Thank you to the three